Let's get to it. Let's start off with the U.S. and El Salvador doubling down on mistakenly deported man despite court order. We're obviously going to be talking about that. It's a pretty significant deal. It is a turning point for the United States in a sea of awful things that the Trump administration has done. We're back at it again. We're back at it again in this field where the Trump administration is actively defying the Supreme Court's unanimous decision on the facilitation of returning the wrongfully deported man from Maryland back to the United States of America. As you guys know, as I've talked about over and over again over the past week and a half, there is, this is a truly horrifying situation. It's unconscionable, it's immoral, and it is also unconstitutional. They're kidnapping people, they're disappearing people into El Salvador, and it's very obvious that this is the modus operandi. They're not going to change it. This is one day after the highly anticipated Oval Office meeting where the president of El Salvador, Nayib Bukele, said he would not return a wrongly deported Maryland man being held in his country in the CECOT anti-terror facilities. The federal judge who ordered his return will hear from the Trump administration's attorneys at a court hearing on this wonderful afternoon. Okay, that's going to be happening in a couple hours. We're, of course, talking about Kilmer Abrego Garcia, who is now entering his second month in the El Salvador mega prison after he was deported there on March 15th, even though there was a 2019 court order that barred his deportation to that country. That means that in an immigration court, Kilmer Abrego Garcia was found to, one, not be a member of any gang whatsoever, but more importantly than that, specifically not deportable to the country of El Salvador, given that he was not only not a gang member, not a member of MS-13 at all, but also beyond that, he had actually given information up on a competing Salvadoran gang, which put his life in the crosshairs if he were to ever return to El Salvador. This is precisely how he got a 2019 court order for a withdrawal of removal. A withdrawal of removal has a higher standard to clear than a pure asylum application. He had sufficiently proven in court that he was endangered. He had delivered information on a Salvadoran gang in the past as well, which put his life in harm's way if he were to ever return to El Salvador. Do you understand? Trump administration officials, on the other hand, claim falsely that Abrego Garcia, who escaped political violence in El Salvador in 2011, is a member of the criminal gang MS-13, and yet they have provided zero evidence. A withhold of removal. Did I say withdrawal? Oh, God damn it. I mess this up every time. A withholding of removal. Unfortunately, withholding is a final order of removal that is withheld, but the government can exercise that final order at their discretion. That is also false. You are wrong. The federal government could technically remove the withholding order. Okay? They could. But there's a process to do that. The Trump administration did not do that. In that court process, you have to go through the details. You have to go through what this person has done, go through their background, and detail out exactly why the previous court order was wrong. They did not process this application at all. There was no due process whatsoever. And to take it one step further, a federal government immigration attorney unironically admitted that they had fucked up. This is why we are having this conversation right now, because when you look at all of the data that civil rights groups and immigration advocacy groups have compiled at this point, 90% of all of the people that have been deported to CECOT right now in El Salvador have no crimes, no criminal background whatsoever. 90%. The only reason why we are talking about this Maryland man is because the federal government admitted that they had engaged in this wrongdoing, specifically because he had the background. He had the previous court order. And yes, Aaron Reichlin Melnick, who I rely on quite a bit, senior fellow at IMM Council, has put together a wonderful presentation of the timeline of Abrego Garcia's gang allegations and what the facts are and what the fictitious nature of the claims are. So let's talk about the actual truth. Let's talk about the background of Abrego Garcia. This is Aaron Reichlin Melnick, senior fellow of IMM's counsel, presenting the full version of Mr. Abrego's time in the U.S. using court documents to explain the allegations of gang membership and what actually happened in his case. Here it is. Entry and early life. 2011 to 2019, okay? Kilmer Abrego Garcia flees El Salvador to the U.S. at the age of 16 after M18 gang members extort his family and threaten to kill him and rape his sisters if they didn't keep paying. He moves in with his U.S. citizen brother in Maryland and lives there without trouble for years. Then comes, on March 28th, 2019, the PGPD arrest. Kilmer is arrested for loitering outside of a Home Depot while looking for day labor. A Prince George's County Police Department detective grills him about whether he's a gang member. He denies any involvement. 4 hours later, he is transferred to ICE custody without the PGPD charging him for any offense. In April 2019, here are the allegations. At a bond hearing, ICE claims Kilmer is a part of MS-13. They submit one piece of evidence, a gang field interview sheet, a GFIS, filled out by the PGPD detective that claims Kilmer is a part of MS-13. The GFIS says he was wearing Chicago Bulls gear, and a confidential informant allegedly claimed that Kilmer was a ranking member of the Westerns clique, which is in Long Island. Except there's a problem there. Abrego has never been in Long Island. He's never been in New York at all. So this evidence is fabricated. And lo and behold, the local detective, as a matter of fact, that accused Mr. Abrego Garcia of being a member of MS-13 was suspended from the police force and indicted merely weeks later for providing confidential information to a sex worker who he was paying in exchange for sexual acts. That's right. I repeat, the cop who initially attested to Abrego Garcia's alleged MS-13 membership was subsequently suspended and indicted for serious professional misconduct. Remember, we're talking about a cop here, okay? If a police officer, a detective, is fired and suspended and indicted for misconduct, that means they must have gone above and beyond. Do you understand what I am saying? So let's continue. An investigation follows in the summer of 2019. Kilmer's lawyers reach out to the PGPD to investigate these claims. They find out that 1, police did not even file an incident report about his arrest, and 2, the detective that had filled out the GFIS has been suspended for an unknown reason. We now know what the reason is. I just described to you what the reason is. In August 2019, there is an IJ decision. At his final bond hearing, ICE declines to offer any evidence of gang membership other than what is in the GFIS. The IJ denies bond, finding that the GFIS is sufficient proof of membership at the time, despite noting its obvious flaws. Kilmer appeals this decision to the Board of Immigration Appeals. Now remember, the immigration courts are an extension of the federal government. They're an extension of ICE, okay? So you have the process where you can appeal to the Board of Immigration Appeals, but ultimately this is somewhat irrelevant because the erroneous decision-making there, it's basically an extension. It's a processor of what the federal government or what the immigration enforcement authorities want to do. That's all they're there to do. They're rubber stamping this stuff, okay? The immigration courts are under the DOJ, part of the executive branch, and not under the judiciary. So just remember that. Having said that, the only reason why I'm mentioning this is because something silly and frivolous like this that is immediately disproven can still cause someone to basically be branded as a member of a criminal organization when there's no evidence whatsoever for it. What is the point of those courts if they just 100% accept everything anyway? It's a way to create paperwork, so to show that there's some sort of process. It's the same principle behind FISA courts. The FISA courts are there to rubber stamp warrantless surveillance and offer them a warrant, right? But it's better that even that exists than not have it exist at all, if that makes sense. Although it is still a rubber stamp protocol, it's still good that even that rubber stamping of the protocol exists as opposed to not existing, because when it doesn't exist at all, then you have no paperwork, you have no way of holding up this process. You have no way of stopping these sorts of things from happening. Now, withholding when the immigration judge rules on October 2019 that Kilmer is ineligible for asylum because he filed the application too late, but the judge does grant withholding of removal, finding that it was more likely than not that he would be subject to persecution if deported to El Salvador. A removal order is issued, but with a restriction that one country he cannot be deported to is El Salvador. Then comes the BIA decision, the Board of Immigration Appeals decision in December 2019. Kilmer appeals the bond decision to the Board of Immigration Appeals. The appeals board declines to find clear error in the immigration judge's decision to rely on the GIFIS document. However, he is released anyway because he had won a withholding of removal. He returns to normal life from 2019 to 2025. By all reports, Kilmer lives a normal life in Maryland with his U.S. citizen wife, their biological son, and his 2 stepchildren, with the work permit he received as a result of his grant of withholding of removal. He works legally as a sheet metal worker, joins a union, and raises his family in a D.C. suburb. He doesn't get into any trouble with the law in these years. And then on March 2025, he gets sent to CECOT. On March 12, 2025, ICE and HSI agents arrest Kilmer in his car in front of his son. 3 days later, he's transferred to Texas, where, thanks to an admitted administrative error, he is put on a plane to El Salvador and sent to CECOT. So this is just a person that is married, that has immediate family members in the United States of America, that was falsely smeared as an MS-13 gang member, and every step of that process, there was enough evidence to suggest that not only was he not an MS-13 gang member, that he was directly at threat by MS-13 gang members if they were to send him back to El Salvador. If they were to send him back to El Salvador, that MS-13, he's so not MS-13 that they would kill him. That is what the courts have found. And yet every single person still that on the one hand admit that they falsely deported him are simultaneously claiming that he is an MS-13 gang member, and also that it's good that he is in El Salvador and there's no way to bring him back. In a normal process, in a just world, Abrego Garcia enters the United States fleeing El Salvador because of fleeing the gang violence in El Salvador, and expeditiously gets an asylum claim that is granted to him. Clearly, if there is a withholding of removal that a court gave him, that literally means that there is enough here, or more than an asylum application, as a matter of fact, more than just a simple asylum application. This means that there is additional evidence that he's presented as to why he cannot be deported to El Salvador, and that a judge oversaw this evidence and said, yes, there is enough evidence here for you not to be deported specifically to El Salvador. It is a higher standard to clear than an asylum application. It is shocking. I guess it's not really unexpected that the administration would be this careless and this inconsiderate, because they are fascist. But just so you know, when people say he's MS-13, that is a lie. That's just a lie. He is so not MS-13 that he is directly in the crosshairs of MS-13, at least according to an immigration judge that said, we can't deport this man to El Salvador specifically. There's enough evidence here to suggest that we cannot, because he is so not MS-13, we cannot deport him to El Salvador, because they'll kill him in El Salvador if he goes there. And yet here we are. I want to point to something here. The very fact that we are even covering this story is because the administration, the immigration attorney on the federal side, admitted that there was an administrative error, because there was one. There was an administrative error. And they admitted that there was an administrative error, which turned this into a bigger story. There are plenty of people that this administration has actively deported that did no wrongdoing whatsoever. Some of them were temporary protected status holders. Some of them were in the process of seeking out their asylum claims. Some of them had been in the country for longer than they could actually process their asylum claim, so they potentially could not get an asylum claim, but they should get one, that they should get amnesty, right? Under normal circumstances, in a world where we have a normal process for immigration, we would file amnesty, conditional amnesty, to all of these people, 90% of them that have done no wrongdoing whatsoever, and now they're in a torture slave prison for the crime of crossing an imaginary boundary and wanting a better future for themselves and their children. Kidnapped in the street. Some of them so falsely and erroneously kidnapped from the street that ICE itself, in the process of said kidnapping, will recognize that it's not the right person. Manuel Gutierrez, sent from New York to El Salvador prison, although family says he has no criminal history or gang ties. He's 19 years old. A 19-year-old Venezuelan in New York City reportedly was apprehended by Trump administration immigration authorities and deported to El Salvador, despite agents realizing he was not whom they meant to arrest in a targeted operation. These are called, I believe they're called like collateral, something along, I forget what the term is that ICE uses, but they'll say like it's a collateral arrest. So, you know, wrong place, wrong time, doesn't matter. we can boost our numbers this way.